client calls you the day they receive a demand letter, what are the two things you tell them to do, and what are the two things you might tell them not to do?
I mean, I usually don't really tell them not to do anything. When a client gets a demand letter, we obviously tell them to issue a litigation hold, which is necessary anytime you get any kind of claim. So it's important to preserve, all the information relating particularly to the accessibility program, what you've done for accessibility. Um, it's also important to try to preserve the website as it was. Um, at the time when you received the claim. Because again, websites change all the time. And so if you're going to be fighting, especially in a case involving damages or claim damages for what happened when the plaintiff went to the website at that particular time, um, you're going to need to be able to say, well, actually, that didn't happen that way, right? The site was fine. Yes, the person could make a purchase at that point. Now, you're never going to be able to go back to the time when the plaintiff went to your website, but at least you can get closest in time if you try to preserve your site at that time, and then you can conduct tests on it. But
Mhm.
that can be quite expensive and challenging. So not all clients choose to do that, depending on the nature of the claim. If we think it's a claim we can get rid of for $5,000, we probably will not be doing things like that. So I think it's important to have counsel when you get one of these. It's important to have counsel uh, who know kind of who the adversaries are, right? Because I mean, how you respond is entirely dependent on who is sending you the letter.
Interesting.
Okay, if you know that this, I mean, so again, you want to hire somebody who has seen, well, who has dealt with everyone. Okay, everyone in the plaintiff's bar. I mean,
Yeah.
we pretty much are that team, but there are others too. And once you know who your adversary is and whether they're going to go the distance, whether they can solve, whether they'll go away for $5,000, whether this is a $2 million case. I mean, it all depends, and that's how you choose your response strategy. Um, the other thing is, the first step is always to figure out, well, what is going on here? Like, are these barriers legitimate? And that too depends on who your adversary is. If you think this is a serious case, then most likely we would hire a consultant, like UsableNet, for example, to assess like whether these barriers are legitimate or not, right? They would conduct tests, figure out what's going on. Sometimes clients have sophisticated in-house teams, and they insist that they want to test for these issues. We, obviously try to be respectful of the internal resources, and if in fact they have resources, great. Oftentimes they will, in fact, confirm that there are certain issues. But we usually prefer when we're in litigation to use outside counsel. I mean, I'm sorry, to use an outside consultant because they have no skin in the game, right? Other than
Different
to,
perspective.
yeah,
Yeah.
it's a different perspective. And uh, they're probably going to be more likely to kind of really uncover all the issues because you want to know what those issues are before you decide how you're going to deal with the case. Um, Sometimes if we have a plaintiff that we know is going to settle very quickly and we just want to verify their problems, we will ask the other side. We'll ask plaintiff's counsel to send us any evidence that they have of a violation. And, sometimes they send us just an automated scan that's not particularly useful or informative. But other times they will have screen recordings showing like, you know, the plaintiff tried to do this and then they encountered this blockage, right? And sometimes that's enough to tell us that there's a problem, enough of a problem that we need to settle this quickly. And then we kind of bypass kind of all the expensive investigative activity and we just settle it for whatever the demand is. So
Mhm.
again, having counsel who know what they're doing and understand like what this particular demand entails and it will involve, I think that's very important.
Yeah, and I think just to piggyback that, I've spoken to companies who have come to us maybe through, our own sourcing, inbound through marketing channels, not through a lawyer relationship that we have. And I'll speak to some companies who tell me that they settled claims for like 25, $30,000. And that always surprises me because I'm relatively familiar with what the average settlement costs, depending on who you're dealing with, obviously, because I speak to so many lawyers and I kind of get a
Hmm.
sense of what companies need to spend to settle. And it makes me think back to what you said in terms of how important it is to have a counsel who knows what they're doing, but I think it's like just as important as they have to know who they're dealing with on the other side, because that helps dictate, to your point, the first few steps they take and can really change the outcome of the settlement costs.
Absolutely. I mean, I think the strategy is entirely dependent on who you're dealing with, honestly. There is no one size fits all um, playbook, I guess, or maybe we have
Yeah.
different playbook. We have different playbooks. We have
Okay.
different playbooks for different scenarios, I guess, is the point.
Is that particular to the ADA accessibility industry where your first few steps depend on who you're dealing with, or is that kind of like how you deal with just, any other claim or lawsuit that a client receives?
I mean, I specialize in ADA Title III litigation, which runs from, digital to obviously
Hmm.
physical access and also operational issues. Within my universe, there is a finite set of plaintiffs'
Yeah.
attorneys. Okay, so
Okay.
and we see them all the time. So yeah, everyone gets a different playbook. I mean, I think the larger components are the same, but how we execute on each one of those components, like the investigation phase, the negotiation phase, all those, the phases are the same, but
Hmm.
how we do those phases is going to be different. And I mean, our goal always is to spend as little money as possible for our client and get the right and good result. So we just kind of leverage all that information. We also, as a firm, we have a big team of attorneys on the AD Title III team. And so we have vast amounts of information about um, the plaintiff's bar and how they settle, and we keep kind of a running database of all of those matters. So we know, like, this firm resolved for this amount, and here is the form that we've already negotiated with them. So we have a starting point. Obviously, clients will differ in what they want, but it just cuts down on the amount of work and
Yeah.
time that we have to spend, right? Because if we just did an agreement and they were okay with this agreement, we use that agreement. And then that cuts down on our time quite a bit.